تطور القطاع القانوني والتجاري له أثر باين على مسيرة نمو دولة قطر. أحد هذه التطورات كان إنشاء محكمة قطر الدولية في سنة 2010.
The Qatar International Court sees itself as a member of an international community of courts that is still growing.
Well, I think the standout memory is probably actually getting it established. That was a wonderful thing. I worked closely with Lord Wolf. That was a great privilege, of course, and with many leading figures in Qatar who were an inspiration to work with.
We all were in agreement with the central theme of promoting the rule of law, and I think we've now moved from a stage where we were something novel and possibly very foreign to something which really belongs to Qatar and therefore is taken root there and is developing and will continue to develop.
لمحكمة قطر الدولية العديد من العلاقات الاستراتيجية المحلية مع شركائها، فعلى سبيل المثال في المجال القضائي قامت محكمة قطر الدولية بانتداب عدد من القضاة من المجلس الأعلى للقضاء للعمل في المحكمة والتعرف على إجراءاتها وكذلك تبادل المعرفة القضائية.
It has a complete reputation for independence.
To put the user of the court center stage.
وجود قضاة في محكمة قطر الدولية من جنسيات مختلفة يتبعون أنظمة قضائية مختلفة، مما يترتب على ذلك شعور المستثمر الأجنبي بالشعور بالطمأنينة.
هذه المحكمة تشكل بيئة خصبة وداعمة للاستثمار الأجنبي في دولة قطر.
What makes it successful is the ability to review certain regulatory decisions, primarily decisions such as the taking away of a license, for example, or imposing a financial penalty, to review that independently. But at the same time, it's very important that there's expertise on the tribunal, because the tribunal is having to do quite a specialized job.
We've invested heavily in technology, which means that we can hear cases without necessarily advocates or witnesses or parties having to come to the court in Qatar. And the fact we have world-leading technology shows the skill of the staff. And I think they're a terrific bunch of people, if I can put it in that way. We do apply sound international practice. We think we do this well and want to expand it and make it available to others. And we want to expand the jurisdiction of the court to serve what the state of Qatar feels are best served by the court.
That can be done and should be done because it makes available in that part of the world a model of the sort of commercial court which can back a country with ambitions far beyond its physical size, as is true of Qatar, have real impact.
طبعا خطط المحكمة هي خطط مواكبة للتطور الذي نشهده في العشر سنوات السابقة، ولعل المحرك الأول لهذه الخطط هو رؤية قطر 2030، ونحن نضع هذه الرؤية نصب أعيننا لجعل دولة قطر مركزاً تجارياً ومالياً في الشرق الأوسط.
The next 10 years will be a period of further achievement for the rule of law.
We owe them a lot, and what I would like to see for the next 10 years is that success continue and deepen and broaden, and I believe it will.
Relationships between counsel, their clients, and the tribunal hearing the case. We also allow foreign representation for offshore cases. That means foreign counsel can register and appear in court. Currently, we have 85 foreign lawyers registered with us, and they come from 15 countries, including civil law countries. This doesn't mean that that's a static figure. If there's a new case, foreign counsel can come in and register. It's quite a simple system. Now, one of the advantages of a commercial court, which is a division of the High Court, is that we have the coercive powers of a Singapore domestic court. And that means we can compel third parties to come into the proceedings. And I think that is something that is very advantageous, because as we know in international arbitration, there's a very thorny problem if you bring in third parties. I've also adopted very flexible procedures. We can do away with discovery under the Singapore rules, and you can adopt the IBA rules. You can disapply certain rules of evidence and common law rules of evidence, like Brown and Dunn and the hearsay rule. And if the parties have chosen a governing law, we will, subject to proof, apply that foreign law. So we also do a lot of active case management right from the start. As Lord Thomas has alluded to it, these case management conferences are very important because the judges are able to control dilatory tactics, something that is very often deployed in international arbitrations. And judges, unlike arbitrators, are trained and whose office allows them to not to give undue preference to due process. A lot of international arbitrators have to worry about their awards being set aside, criticisms against how they handled it. But I think judges handle this much better because we have the force of our office behind us. So case management, I think, will help deal with dilatory tactics. An interesting feature that we will have in 2021 is that we're going to introduce new procedural rules. We will have only one method of commencing proceedings, but then we have three tracks. We have the pleadings track, which is familiar territory, which is filing of pleadings and witness statements. And we have a statements track, which is like the originating summons, and we even have a memorials track. Now, I think it is important that, as Lord Thomas says, international courts need transparency, and our cases are heard in the open, and they are reported. And we have to date issued 60 judgments, 14 judgments from the Court of Appeal, and one of them, for example, involves an ISDA master agreement, which ISDA was very pleased with. And on another, for example, we had a Court of Appeal decision on unilateral mistake in a cryptocurrency trading platform, which went wrong and the trader made a lot of money. And what was unusual about this was that mistake happened without human intervention. It was all done by algorithms. However, if parties want confidentiality, they can apply for hearings in camera. There are also interesting issues of enforcement, but as Lord Thomas says, CIFOC has done very well with the Memorandum of Guidance, and there are 30 countries that have signed on to it. So I think the future for the international courts very bright. I think businessmen are going to turn more and more to that form of dispute resolution, and they're going to see that the commercial judges and the commercial courts are going to interact and cooperate and attempt much more in terms of harmonization. Thank you.
Thank you so much, Justice Lowe, for those observations about the Singapore International Commercial Court, and for elaborating on the nature of the judges and that the international nature of that, and also the unique features. Listening to you and hear about the ability to act as a court and compel parties, and the ability of the parties to, in effect, have tailoring as to discovery as well as to the evidence. I know those are some unique features of your court, and to remind us of the significance of case management throughout all of this. And we look forward to the new rules in 2021. We will now hear from President Oranje. President Oranje from the Netherlands Commercial Court.
Thank you very much. Good morning, and I guess good afternoon as well. depending on where you are. I'd like to take the opportunity to tell you something about the Netherlands Commercial Court, as we are a rather recent court, and for the moment, I think we are the first, and maybe, yes, at the moment we are the only entirely English-speaking international court. I can't say in Europe, but in the continent of Europe, of course. The Netherlands Commercial Court started with an investigation in 2014 in respect of the possibilities and the prospects of a Dutch international court. And that was followed by a process of legislative review and the drafting of the appropriate rules of procedure. In the Netherlands, many organizations were involved in these proceedings. Consultations were held with stakeholders from the industry, legal practice, the judiciary, and the Ministries of Economic Affairs and Security and Justice. A project committee was subsequently set up, consisting of judges, appeal court judges, and associates of the Council for the Judiciary in the Netherlands. The committee investigated the various legal and organizational aspects that would be relevant for a Dutch commercial court. An external focus group was set up, consisting of representatives of Dutch companies operating internationally, employer organizations, and the Netherlands Association of In-House Lawyers. The law providing for the NCC in the Netherlands has now been enacted as of 1st of January 2019, so that's only last year. And on 8 March 2019, the NCC issued its first judgment. Now, why a Netherlands commercial court? There has been a proven demand in the Netherlands for specialized English language proceedings. Commerce is becoming more and more international, and transactions are becoming increasingly technical in a legal sense, and English in the Netherlands is now becoming the working language. Litigation in the Netherlands in Dutch is impracticable for international companies with departments located all over the world, and who correspond internally and with their counsel in English. The dispute resolution is moving away in the Netherlands. International dispute resolution is moving away to from the regular courts to arbitration and to foreign English-speaking judicial systems. The Dutch courts have a good reputation internationally, and Dutch justice is seen as reliable and predictable. Additionally, Dutch procedural law and Dutch legal fees make it a very affordable option. Now, the NCC is part of the Dutch judiciary. The proceedings are in accordance with Dutch procedural law. In addition, procedural rules have been drafted specific for the NCC, tailoring the proceedings to established international practices. The NCC is not a new court. It is a chamber of the Amsterdam District Court, and for the appeal, it is a chamber of the Amsterdam Court of Appeal. For the parties to elect the NCC, that is, to opt for proceedings in English in accordance with the specific NCC rules, it is necessary that they designate the Amsterdam District Court as the competent forum, and they have to express their consensus for the proceedings to be conducted in English in accordance with the NCC rules. Parties may agree to litigate before the NCC, either before or after the dispute has arisen. The most important feature of the NCC is that the proceedings are conducted entirely in English, including the judgment. Now, what cases can be brought before the NCC? The objective is to focus on major international commercial disputes, exclusively on account of its expertise and mode of process. It is possible to present collective actions to the NCC, provided, of course, that the parties have agreed to bring the proceedings before the Netherlands Commercial Court. There is no financial threshold for the NCC, and this was so decided because also matters with a smaller financial interest can be complex, and parties may wish to bring this before the NCC because of its international expertise. As to the court fees, to ensure that the NCC does not burden the budget of the regular courts, it has been stipulated that the NCC must be financially self-supporting. And in line with this, the NCC court fees are higher than those of the Dutch regular courts and are based on an estimation of the amount of cases which we will handle and are handling and the average costs of dealing with the case. The court fees for the NCC in all matters is €15,000 in first instance and €20,000 in appeal. The judges are judges from all courts in the Netherlands who have extensive experience in international commercial cases and have a good command of legal English. As I said, specific rules have been drawn up for the NCC. A few I'd like to mention. First of all, the point of departure in all cases is a case management conference. This is an informal and practical hearing, and usually not a one-off event, but may be held whenever an occasion occurs. The purpose is to enable a decision quickly and effectively, and to make it clear to the parties what is expected from them from the very start. Motions are to be brought concurrently, and as much as possible, be disposed of and decided within short time limits. All cases are assigned to a dedicated judge who takes all process decisions, besides over the hearings, including in the introductory case management conference and all the hearings of witnesses. He remains in charge of the case until the final judgment, and in addition, there is a designated clerk who remains associated with the case during all time. The rules endeavor to be in line, that is the specific NCC rules, endeavor to be in line with the litigation practice in the existing commercial courts and in international arbitration institutes, such as the IBA rules on the taking of evidence in international commercial arbitration, as this promotes an efficient way of litigation and is familiar to foreign parties. All proceedings for the NCC are conducted entirely digital. That is, there is a separate digital portal in English, specifically built for the Netherlands Commercial Court, by which the proceedings can be initiated and all documents and exhibits are uploaded. All correspondence with the court is done by means of this digital portal. Now, like all other proceedings in the Netherlands, the NCC proceedings are not confidential. NCC may rule, however, that certain information must be kept secret, and it can set penalties for a breach of such an order. The judgment itself, of course, will be pronounced publicly, as such is required by Article 6 of the Convention for the Protection of Human Rights and Fundamental Freedoms. So we started on the 1st of January last year, 2019. The first case was brought on 11th February 2019, which was an Irish company against a Dutch company and regarded the enforcement of a pledge on shares. Hearing on 18th February and judgment on 9th of March. So we tried to, not to be slow, so to say. And subsequently, 8 cases have now been brought by an English party, Russian, Canadian, German, and American, and involving a wide range of cases, such as shipping, tax, software, lease of a ship, the purchase of racing horses, and so on. As to COVID-19, as the proceedings are entirely done through the digital portal, the COVID restrictions mainly relate to the hearing itself in court. I hope you can still see me, because I see. Can you still hear me?
Yes, yes, we can. And I just chimed on if we could just have a few concluding remarks, President Oranje. I think you were going there. So, yeah, thank you.
I thought you shot me away there in a James Bond sports car.
No, sir, we'd never do that.
Okay, I was just finalizing to say something about the COVID-19, because we're a bit proud of how we managed that. On 10th of April this year, we held a first hearing via Skype. And what we do is we have a test in advance, like we actually had this morning. We do not admit pleadings, and certainly not long pleadings. Pleadings are to be uploaded before the hearing. Microphones are to be muted. we give strict instructions that only one party is allowed to speak at the time, which for a judge is a nice order to give, of course. If a lawyer wishes to discuss something with his client during the hearing, and it might be that they're not in the same room, then they will have to do so by telephone. And finally, lawyers need not wear the gown, the toga, but the judges usually do, because we then usually sit in court. In urgent matters, which has happened, the judge sits at home, and then you would see me like I am now. The hearings are, of course, in public, so that was not easy, but we have now arrangements that anybody who so wishes can attend the hearing, provided they are registered in advance. May I finish now? Thank you very much.
Yeah, thank you so much, President Oranje, for giving us the background on the court, the significance of English. Again, focus on case management, which seems to be a consistent theme, and grateful for those remarks. Judge Brouwer, the floor is yours, and I think you've heard already some of the comments about arbitration, so you may want to shed some light on that with regard to the fact that we now have these institutionalized commercial courts. But we look forward to your remarks. Thank you. And Judge, please unmute. Thank you.
You would think by now I know where to unmute. Yes, I do. Thank you. Thanks for the tip. My long experience at the Iran-United States Claims Tribunal, which is a rather unusual animal, has been supplemented by sitting in a series of hearings in 3 cases as judge ad hoc at the International Court of Justice, and in 1 case as judge ad hoc at the Inter-American Court of Human Rights. And the 3 could hardly be different, the one from the other, but there are common elements, obviously, with the commercial courts. In the case of all 3 of these, one of the questions is how well have they worked, and how, if that's the fact, they've come to earn the trust of the users. Now, one aspect we have in common is that all of these 3 courts or tribunals have nationals of various countries. Now, of course, in the case of the Iran-United States Claims Tribunal, it exists only because 52 American hostages were seized in Iran in 1979. Hard to think back into the 20th century here in 2020. And it arose in order to settle disputes that arose during the Iranian Islamic Revolution. Now, of course, there are only, in the 9 judges, there are 3 Iranians and 3 Americans, and then there are 3 others who have always been 3 from third countries. Actually, presently on the American side is Sir Christopher Greenwood, formerly of the International Court of Justice. He's the only non-American who has been appointed by the United States and works on the American side of it. So this is not your typical international tribunal, but the interesting thing is that though both the 2 countries have not had diplomatic relations since about the time the United States Army Delta Force landed in Desert 1 in Iran in April 1980 on a mission which failed to extract the hostages from Tehran. These are, it's basically a kind of a confrontation. On the other hand, by the filing deadline for most cases, which was January 19th, 1982, the docket was fixed. There are not new cases coming in unless one of the states complains against the other of having violated the accords in some way. But it's processed all of the basically commercial cases involving private entities who were expropriated or suffered contract breaches, almost exclusively American claimants. And surprisingly, it seems to work rather well, and I think it has a good reputation for having solved a lot of issues that arose largely of a commercial character during that time. Now, the other two courts, the Inter-American Court of Human Rights and the International Court of Justice, of course, according to their statutes, require that there be no two nationals of one country. In the Inter-American Court of Human Rights, they have 7 judges, and they all have to be nominated by members of the Organization of American States. Now, its field is obviously entirely different, and it has a docket that can always be renewed by new cases coming in, basically via the Inter-American Commission on Human Rights, which sits in Washington. Same for the International Court of Justice. It has 15 judges plus judges ad hoc in particular cases, and it's busier than ever. When I arrived in The Hague at the end of 1983 to take up work at the United States Claims Tribunal, everybody was jealous of us, not just because we were the new boy in town, but the International Court of Justice had either 0 or 1 case on its docket. It was not well used or thoroughly used. Now it is almost, I shouldn't say not overwhelmed, but almost overwhelmed by the number of cases that they have to deal with. They come in all the time. And the fact in both, all of these 3 tribunals, the fact of nationals of different countries does make a difference. And it's not just the question of civil law system and common law system, but there is a lot of interesting cultural background even surrounding the legal systems, and I think it works very well. In the case of the International Court of Justice, actually the statute in Article 9 says when the judges are elected by the Security Council and the General Assembly of the United Nations, they must respect the following, quote, "In the body as a whole, the representation of the main forms of civilization and of the principal legal systems of the world should be assured." And so we have people from all around the world, from all of the main continents, sometimes from New Zealand and Australia as well. Interestingly, in the international tribunals, generally, there are not what you would know as rules of evidence in domestic courts, and I suspect they apply also in the commercial courts. Because only states are involved, and I think there is a reluctance to apply common rules of evidence, which are based on suspicion about the evidence that comes forward. In the United States Claims Tribunal, we have had also pre-hearings in the cases involving nationals, particularly of the United States, who have had claims there. As far as the consistency of jurisprudence, I have to say in what you would call the commercial cases, we operated in 3 different chambers, and it developed what I referred to as the sovereignty of the chambers, because they could never get together on how they would handle interest and oftentimes cost as well, although the main jurisprudence was fine. And I will wind up by saying everybody probably in all of these cases would like to have the same Article 5 from the one of the declarations that established the United States Claims Tribunal. The governing law provision reads as follows: The tribunal shall decide all cases on the basis of respect for law, applying such choice of law rules and principles of commercial and international law as the tribunal determines to be applicable, taking into account relevant usages of the trade, contract provisions, and changed circumstances. Now, if that's not a license to do what you think is right, I don't know what is, but there have been practically no disputes over actually how to apply the law in particular cases. Thank you very much, and I congratulate the Qatar court and everybody who's putting these courts together. Although I spend a lot of time as an international arbitrator, I don't feel endangered, and I think these courts are great. So hallelujah.
Thank you so much, Judge Brouwer, for those remarks, giving us insights in particularly the role of the judges in nationality issues. And then secondly, I really enjoyed hearing the authority of the court, the Iran U.S. Claims Tribunal, and the statute that you just read out, and the way you could seize on that, and of course your respect as an arbitrator for these courts too, to seeing that this is not a zero-sum game. I would now like to pass the floor to my colleague, Professor George Dimitropoulos, just to give us some reflections. Professor Dimitropoulos, the floor is yours.
Thank you. Thank you so much, Susan. I'll try to keep my remarks brief, but I would like to begin without thanking Lord Thomas, Faisal El-Sahuti, and Christopher Grout for having us and having me here today for this celebration. Thank you very much, as well as the IBA, of course. I won't be using the slides, so no worries. I'll keep my remarks very brief. Thank you very much. As well as the Dean for introducing me, as well as mentioning that this is part of research that I've been working on with my colleague at the Queen Mary University London, Stavros Brekoulakis, and with a forthcoming book on international commercial courts with Cambridge University Press. Now, I would like to first highlight, let's say, the differences among the three, what I call different types or categories of international commercial courts, and close with the remark on potential convergence of international commercial courts. So I think there are, one could classify three different types of international commercial courts that in a way explain the differences that our judges today have highlighted in the different ways that the courts address issues of the judiciary that they have on the bench, applicable law enforcement, as well as a relationship with arbitration. So the journey of international commercial courts starts in the Gulf, right? Within the special economic zones of the Gulf, and then start moving towards Asia, East Asia, and then coming back to Central Asia, and then eventually settling in Europe. So there are three types of international commercial courts, according to my research, as far as one can tell. International commercial courts that are embedded within a special economic zone. The four examples that we have here are the DIFC courts, Dubai International Financial Center courts, of course, our own court here in Qatar, the Qatar International Court Dispute Resolution Center, the Abu Dhabi Global Market courts, as well as the Astana International Financial Center court. The characteristic of these four courts is that they are embedded within a special economic zone. So they are defined by their embeddedness within the special economic zone. Then we have a second type of international commercial courts that could be identified as standalone international commercial courts. And what one could identify here as the Singapore International Commercial Court has been part thereof, as well as the China International Commercial Court. Now, the characteristic of this category of international commercial courts is that they define a new jurisdictional category, a new jurisdiction for cases that are international and commercial in nature. That was the innovation of the Singapore International Commercial Court, which was taken adopted, let's say, by the China International Commercial Court a couple of years later. And then one could say that there is a third category of international commercial courts, which are actually chambers within international chambers within the ordinary structure of a domestic judiciary. The three examples here are the Frankfurt, the Chamber of International Commercial Disputes at the Landgericht Frankfurt am Main in Germany, in the state of Hesse, the international chambers at the Paris Commercial Court and the Paris Court, as well as, of course, the Netherlands Commercial Court. Here, the major characteristic, and as President Oranje also discussed, is that there is some sort of tweaking, let's say, of the procedural rules for domestic courts, whereby resorting to domestic judges that have an excellent, good command of the English language, as well as possibly some previous exposure to the common law, let's say, or English law. So I would like to highlight that the differences that there may be across the different international commercial courts have got to do with the roots, the way they have been brought to life, as well as the institutional embeddedness of the different courts in the different institutional environments of the countries, as well as the special economic zones within which they have been established. Now, Susan, won't take much longer. I would only like to highlight one or two points. One point on with regard to the judiciary. The interesting aspect of special economic of international commercial courts that are embedded within special economic zones is that they are free, let's say, to draw on judges from all over the world, and there is a clear preference for judges that are drawn from from England and Wales, as well as, broadly speaking, the common law world. The Singapore court has, of course, a very interesting system approach as well, whereby there are the domestic judges and then a panel of international judges. And I will close with one comment. I will start closing with one comment with regard to the relationship between international commercial courts and arbitration. What has been happening practically is the increase in the powers of international commercial courts as curial courts in arbitration. Let's say this is a power that was gained by the Singapore International Commercial Court 1 or 2 years after its establishment, and Justice Lowe can correct me on this. And a power that the special economic zone courts have been gaining over the course of the last couple of years. Now, these are, roughly the differences across the three different categories of international commercial courts. Now, is there any convergence, as Justice Lowe alluded to before? There may be. As far as I can tell, there are yet to cross references to cases of other international commercial courts to be made, references namely of the case law from other international commercial courts to be made. But I'm pretty confident that this is something that we're going to roughly see in the very near future. The actual point of convergence when it comes to the three different types of international commercial courts, particularly the courts of the two first categories, is the pool of judges. Namely, what we've started observing is judges that have appeared before one international commercial court to then, after retirement or at the same time, to be operating as judges in a different type of court. This has happened at least 2 cases, for example, with judges of the Singapore International Commercial Court and the DIFC courts. I will leave it at this, and I will be happy to further discuss about this and any other point.
Great. Thank you so much, Professor Dimitropoulos, for that overview and the 3 categories. I think it puts all the remarks we heard before in an informed context. And secondly, the emphasis again on the judges. And I think that this is, and each of our distinguished panelists spoke on this topic, but it's a good way to launch a conversation about a question that came in, and it does deal with the Singapore International Commercial Court, and it is directed to Justice Lowe. And thank you, Professor Dimitropoulos, for reminding us about the national and the international group of judges that the Singapore court has, but Singapore has a couple of other things going for it as well. And so this question is as follows. Singapore has been very successful in attracting dispute work, litigation, and arbitration throughout the Southeast region. And so, Justice Lowe, what suggestions could you offer to commercial courts, for example, in the Middle East, on how to attract regional business?
I would say this. Singapore is very lucky because of our position. And actually, I see the same advantage of the courts in the Middle East. You sit between different economic blocks. So when they want to look for a neutral court and a neutral place, you become the natural choice. Second, I think you need a very stable government, a very safe environment, good connectability in air traffic, in your telecommunications, and most important, you need judges. Judges with solid reputations, just like the English commercial courts and how they grew in success, as well as judges, I think very importantly, who are incorruptible. An Indonesian businessman gave us once a very great compliment. He said, if I lose a case in Singapore, I can say the judge was stupid. I can say the judge didn't understand my case, but I can never say the judge took a brown envelope. And I think that's very important. The parties must leave at least with the knowledge that they had a hearing, it was fair, and there was no corruption involved. Thank you.
Great, thank you. Thank you for that response. I am curious, Lord Thomas, in light of the question, if you have any comments on it, because it is aimed at the way the Qatar International Court perhaps could be doing business to meet the business objectives.
Well, can I thank everyone for this fascinating discussion, but can I follow up immediately on what Justice Lowe has said? First, I agree completely that the judges must be seen to be independent, completely uncorruptible, and not susceptible to any form of influence, local or otherwise. Secondly, they must have a solid reputation and be able to deliver judgments that will withstand not total international scrutiny, i.e. they're of the highest standards, but can bring with them the ability to blend cases. We have an interesting case, I believe, coming on appeal in Qatar at the moment about issues as to the award of interest on money due. And this is an important illustration of where these courts can go in blending traditions and providing an authoritative way forward. But I also think that what is vital is making it clear that that all counsel, wherever they come from, can speak and address the court, that everything happens in public and is properly accessible, so there is no suggestion of anything happening other than in accordance with the highest international standards. And as has been mentioned, the ability to do everything in public and also to carry out enforcement. I regard enforcement and the progress CEFOC has made on this as critical to the future, because we want to make certain that judgments of each of these courts are respected by other courts who have the ability to enforce them. Just as in Qatar, one of the things we have the ability to do is to enforce the judgment of other commercial courts where they relate to matters within the jurisdiction of the Qatar court. So I think all of these things come together, but we are truly an international body, dependent upon working closely together with judges like Judge Lowe and President Oranje in building a better world for people who need their disputes settled quickly.
Great, thank you for those observations, Lord Thomas. We have only 3 or 4 more minutes, but there is a topic that a question has come in on, and it hasn't been addressed, but I'm sure each of your courts and Judge Brower in the various courts that you worked on it and in arbitration, I think is critical, and that is the growing influence of mediation. Have you been involved in your specific courts in efforts to try to promote mediation? And if so, how effective has that been? And then I think that will be the last question we can take since we are needing to wrap up. So I think I'll first ask President Oranje and then Judge Brower too, in the context like of the Iran U.S. Claims Tribunal, if there's been any effort, and then we'll hear from Justice Lowe and then from Lord Thomas. Thank you very much.
As to mediation, I guess in the Netherlands, mediation has become very popular, but it is always seen as a sort of an alternative for the regular legal proceedings. So I've always seen the need for mediation as a reason for the regular proceedings to improve. And I therefore think that what we are aiming at in the Netherlands, and I think we are probably not the only one, is not so much being impartial, because we take that for granted, fortunately, and fortunately we're not the only country. I think it's three, in essence, it's all a matter of costs, time and expertise. And I think that the need for mediation will decrease if we manage to do the proceedings for less costs and quicker and done with expertise. So yes, there is an increasing need for mediation, but I think we can counterweight that by providing that what we think parties really need.
Great, thank you so much. Judge Brower, and if we could all just be I don't know, Christopher, if we have a minute or two beyond that we could go, but if everybody could just be a little quick on this subject. I want to hear the insights though, of course. Thank you.
I would say that mediation is, I'm unmuted, right? Yep. Mediation is not really known in any of the international courts of which I've been a part, but at the Iran United States Claims Tribunal, we have the power to issue an award on agreed terms. In other words, when the parties decide to settle, which usually happens after there's been a hearing and somebody sees that maybe there has an idea of which way things are going, they come in and settle. And of course, our awards on agreed terms, just like an award following contested terms, is enforceable under the New York Convention. As to mediation, I will say I've learned a lot about the Singapore Convention on Mediation, which I think is a tremendous development. And I think that because it gives you, if you meet the conditions, the same powers that are available under the New York Convention on Arbitral Awards, I think we'll be seeing a lot more mediation. And as an international arbitrator, of course, mediation often is a term, a condition in a bilateral investment treaty that one has to go through before going to arbitration. Thank you.
Great. Thank you. Thank you so much. Professor Dimitropoulos, I meant to ask you as well if you have any comments on this.
No, thank you so much, Dean Karamanian. No.
Okay, great. Justice Lowe and then Lord Thomas, please.
I'll be very quick. One, mediation, neutral evaluation is very much on our minds. You raise it during our case management conferences, sometimes in the beginning, sometimes midway. We have a feeling it's right, we send it off. Second, in complex litigation, we often encourage parties to break up the claim into discrete parts, some of which can go for mediation or neutral evaluation, and then the big issues we go to court. Thank you.
Thank you very much. Lord Thomas, please.
Two sentences. We have found mediation has worked in the course of cases, and some of the judges have switched to doing mediation and withdrawn from the case. As a result of that, we've decided and recently established a mediation panel. We've given quite a lot of publicity to this, and I don't want to take up any more time.
Great. Thank you so much. And I imagine on the websites of the various courts, there'd be information about this too. I would like to, on behalf of Hamad bin Khalifa University College of Law, and also on behalf of my colleagues here, thank first the Qatar International Court and Dispute Resolution Center for the opportunity to be part of this important conversation. Secondly, again, thank the International Bar Association for making this event possible. And of course, a big thank you to Lord Thomas, Justice Lowe, President Oranje, Judge Brouwer, and Professor George Dimitropoulos. We had a wonderful conversation, and we look forward to more of these as the courts continue to develop. And again, happy birthday to the Qatar International Court Dispute Resolution Center. Thank you so much.
Thank you so much, Susan, for doing such a good job of moderating the session. And the final point I would make is we've had a number of queries come in from individuals who are watching, asking if any of the material that we've discussed today and presented can be made publicly available. So from the Qatar's perspective, we will certainly make our material, including the video we were unable to show at the beginning, available on our social media platforms. So you can follow the court at QICDRC on Twitter. But if anybody else has presentations that they're happy to share with participants, please let me know. And then attendees can reach out to us and we will share them if and when we're able.
Great. Thank you so much. Have a good day.
Thank you.
Thank you.
Thank you.
Thank you, everyone.
Bye.